Good morning, everyone.
Good morning.
Thank you so much for making the appointment. The organization Undoing Tax Abuse, OUTA, through their lawyers, have demanded that the SAA board refrain from signing any agreement with BNP Capital for the sourcing of funds or make any payment to them for sourcing funds as the procurement process was unlawful. Should SAA proceed with the agreement or make any payments, OUTA will take legal steps to ensure that public funds are not wasted on the grossly inflated charges of BNP. An ongoing investigation by OUTA into the dealings of SAA has, amongst other dubious findings, revealed that SAA are about to enter into an unlawful agreement with a small yet relatively unknown financial advisory firm, which has had its Financial Services Board license suspended. The agreement is unlawful in that SAA, as a matter of urgency, indicated that they were not able to follow competitive bidding procedures, but were forced to increase the scope of an already existing bid awarded to BNP to the tune of 2.8 million, and furthermore select BNP to source 15 billion rands in funds for them at a 1.5% success fee, that equaling 2.5, or rather 256 million. That includes VAT. This urgency allegedly rose from the fact that 7.3 billion rands in loans were payable by the end of June, and that this was pointed out to SAA by BNP Capital. SAA further stated that this percentage was in line with market norms and that other efforts to source funds without BNP had proved to be unsuccessful. Various whistleblowers have indicated that this explanation by SAA's senior management is not plausible, as the maturity of loans was not new news to SAA, but was regularly discussed in various committee and board meetings and was included in various documents of SAA. Over and above the implausible explanation surrounding the urgency, it appears from a quote sourced from the banks by SAA's group treasurer that the funds could have been secured for between 170 and 240 million, less than the fee negotiated with BNP Capital. In other words, the success fee herein was overstated. OUTA has various questions regarding the awarding of the bid to BNP, which they encouraged to answer truthfully. Also, we are in possession of information substantiating this. These are the questions we are tabling to SAA. Firstly, how is it possible that SAA lost BNP's bid, that is BNP's initial bid, but BNP later resubmitted their bid and coincidentally came in at an amount lower than the other competitors at 2.8 million rand, only 100,000 rands above the internally estimated bid price. Furthermore, why has the date on the SAA stamp on the BNP bid been outed by pen to the 18th of March, which coincidentally was the last date that the bids were permitted to be submitted? How is it possible that BNP included the sourcing of funds in their bid when the request for proposal never made any mention of the sourcing of funds? How could BNP include their finance or their references for projects completed by the company, wherein Daniel Mahlangu, sole shareholder and director of BNP, is also a director of that company? How is it possible that SAA are willing to enter into business with a company that has its FSB license suspended when this prohibits the agreement from being entered into? We're encouraged to see people coming forward and exposing unlawful behavior within government institutions. We also encourage any whistleblowers within SAA to contact OUTA as soon as possible without additional information, additional information, so that we can address maladministration and corruption together. OUTA hereby indicates that its strategy going forward is to hold the board of SAA accountable for ongoing transgressions of the law over the protracted period, which could include an application to have board chair Dudumieni and other board members removed as directors. OUTA maintains that it is the responsibility of the directors of state-owned entities to always act in the best interest of their organization, thereby always having the best interests of the public purse at the forefront of their minds at all times. We will be getting into our presentation, basically demonstrating our findings in as far as this case goes. I would like to invite our Director of Legal Affairs, that is Ivan Hasselman, to go through with it. We'll go through it together.
Thank you, Rita Bile. Thank you very much. Very well. So we've done an investigation over the last few months, and our investigation has led us to various sources that provided us with a variety of information that brought us to the conclusions we're going to present to you today. These are preliminary conclusions as the investigation is ongoing, and we are positive that the whole body of information we have of various other transactions outside purely of this transaction will put us, and by putting us, put the public in a position to effectively challenge the ongoing transgressions within South African Airways. This project started off with a request for information published on the 7th of February 2016 in the Sunday Times. Now, the normal procedure for a request for information would be that that bidders have 14 days to submit their bids. But curiously, this time around, they only had a week. Thereafter, a document was circulated internally within South African Airways, indicating that this bid, the request for proposals, would be for the sourcing of funds and transaction advice. After a lot of resistance within South African Airways to this notion, the document was changed. Changes as follows. The full scope of the bid only included the analysis of SAA's loan agreements to determine the inefficiency in the total funding, advise SAA how to restructure its balance sheet through the settlement of inefficient loans, and advise SAA on the strategic loans that on the face of it appear to be inefficient, etc. Now, nowhere in there would you see the words, the sourcing of funds. The sourcing of 15 billion rands worth of funds, which is a phenomenal amount, and the success fee for any company, even at 0.25 basis points, also equates to a phenomenal amount. Yet, the bid presented by BNP Capital very curiously included the raising fee will be charged at 1.25% of the amount raised. We are awaiting a plausible explanation of how they would have had that information. Even more curious, later you will see that the interim CFO of South African Airways misrepresented the state of affairs by indicating that she negotiated down the price, the success fee, from 2% to 1.5%. These are the people within BNP Capital. Mr. Daniel Mashlangu, Vuvani Metabula, the CEO, Irvin Moya, Tamasanka Neta, and Yannick Ntanke. On the 21st of April, board approval, it would appear in principle, is given for the extension of the scope to go outside pure transaction advice and to include the sourcing of 15 billion rands worth of funds. The extremely dubious motivation for increasing the scope is that 7.3 billion rand are maturing on the 30th of June 2016, and SAA is obliged to settle the loans on or before the maturity date. Due to the time constraint, the only feasible approach is to engage the appointed transaction advisor to urgently source the funds required to settle the loans. Sourcing of funds was not included in the transaction advisor's scope of work, as SAA believed that the funds could be successfully sourced without the transaction advisor's assistance. We'll indicate to you in a bit why this explanation, as Ritabili has alluded to, is completely implausible. An unsigned document was initially circulated wherein the fee was 2%, equating to 300 million rand for sourcing the funds. We have reliably heard that this job would not take more than 2 months. Even more peculiar, that they state there are none Public Financial Management Act implications at that stage for confining an award for the sourcing of 15 billion rand. At a later stage, a signed motivation for 225 million rand, excluding VAT, is put before the bid adjudication committee. This was what the interim CFO alluded to are the fruits of her hard work negotiating efforts to bring down the costs for South African taxpayers and the public in general. The parties that signed it, curiously, some of the names have been crossed out and other people have signed. Here you will see the cost of one of the greatest theft exposés our country has ever seen. Very curiously, on the 24th of May 2016, full board approval is given, even though various of the parties only signed the resolutions on the 27th of May. What exactly that means, we are not sure, but seen in the context of all these dubious allegations against SAA, it is curious. After the bid was awarded and confined, the Treasury Department within South African Airways attempted to get a hypothetical quote from the banks on what their fees would be should they arrange the sourcing of funds. They indicated that it would be between 42,750,000 and 5,500,000. At the top you can see the costs of BNP Capital, 256,500,000 rand, being between 170 million and 214 million rand more than we would have initially paid had the bid possibly gone out competitively. Next, you will see in the bid documents there are critical criteria to be able to continue with the bid. At the bottom you will see Financial Services Board license. It has been ticked. This is the website of BNP Capital and a copy of their Financial Services Board license. However, we have learned that the FSB license of BNP Capital has been suspended. And after consulting lawyers that have worked in the field, we have reliably learned that the reasons for suspension are not simple transgressions, but would have been serious transgressions. Here you can see a screenshot from the FSB website wherein it is indicated that the FSB license of BNP Capital has in fact been suspended. Our understanding is that even though a letter of award has been given to BNP Capital, that they are quoted in Business Day yesterday as stating that the agreement has not yet been signed. We are thus of the opinion that they can no longer sign the agreement and can no longer continue with this transaction, as according to the critical criteria, they no longer comply. What we discussed earlier is the motivation plausible? Did the maturing of the loans jump upon them? Did the maturing of 7.3 billion rands worth of loans jump out of a closet and surprise them? The explanation is extremely implausible according to various sources within SAA, as they have regular meetings when they discuss the maturity of loans. They draft borrowing plans wherein they discuss the maturing of loans, and they address the maturing of loans at executive committee meetings and board meetings. As in 2015, they even attempted to source 15 billion rands worth of loans, but because various service providers said that they would not consume the entire risk, but give 2 billion here, 3 billion there, 1 billion there, the deal was shot down by the board of SAA. As I just stated, that this statement is false. They said that the sourcing of funds was not included in the transaction advisor's scope of work, as South African Airways believed that the funds could successfully be sourced without the transaction advisor's assistance. The outcome of SAA's efforts to secure the funding without this assistance of the TA in the market has proved otherwise. The versions we have heard is that this is a manufactured state of affairs and that this is not the truth. What in fact happened is that a company approached SAA last year but did not produce all the documentation required for them to be able to consider it as a bidder, and as I stated earlier, the others were not willing to consume the entire risk of 15 billion, and therefore the board shut it down. This version, this statement, is also not the truth. The industry norm that transaction advisors charge a success fee ranging from 2 to 3% of the funds sourced, and SAA negotiated this success fee with the transaction advisor. The two parties settled for a success fee of 1.5% should BNP Capital be tasked to urgently source the funds. We have reliably heard that SAA has previously sourced 5 billion rand from financial institutions for a fee of 13 million rand, and the hypothetical quotes received once again indicate that they would have been able to achieve this purpose at between 170 million and 214 million rand less than they would have if they continue with the services of BNP. We have a lot of questions and which we would like answering, and we give a stern warning to SAA that not to lie. We have corroborative documentation for this. So come out and talk the truth. Who is Inline Trading 10? The joint venture partner of BNP Capital. Why did a company with a history of only white directors get a black director on the 5th of February 2016 and enter the bid on the 7th of February, the day of the opening of the request for information? We cannot draw a conclusion, but we ask the question. Why does your joint venture partner appear to be somebody who sells luxury vehicle motor parts or merchandise, and their shop front is in a little shop? How does that work? Possibly they could explain. Is Daniel Mashlangu, the director of BNP Capital, advising himself, as he is our director of South Point Management Services? That is from their bid, where they indicated that that BNP Capital provided financial advisory services for the purchase of a company in 2015, the transaction totaling 780 million. We ask the question, Mr. Mashlangu, are you advising yourself? Because you are now a director of South Point Management Services. Why were bidders only given a week to reply to the RFI when the policy clearly states 2 weeks? We require an answer for that. Why were bidders also only given 1 week to reply to the request for proposals when the policy clearly states 2 weeks? We're still waiting an answer. How is it possible that the BNP bid was lost by South African Airways, submitted past the closing date, and was lower than the lowest bid and only 100,000 rand higher than what we have established from an internal document the costs were estimated at. Very curious. Something that's not in here that we've also established is that BNP Capital are not trading from their registered address. They are trading from a different address where a different business is registered, which is also in itself curious. There are a lot of other angles we could have indicated today, but the evidence still has to be matured and we will make new revelations within time. Thank you very much.